Contract law provides certainty for the wheels of commerce. It's going to regulate the relationship between legal parties when they have transactions. It doesn't just regulate the transactions, it regulates the dispute resolution if things go badly, it regulates how they start, how they end, and the terms in the middle. So without that certainty, without knowing that the exchange that we make is going to be fulfilled in the way we expected it, how would our economies actually function? If we weren't actually certain that this is going to have the result that we all intended it to have, we wouldn't be able to make any deals and the economy would basically, stop.
Basically, contract is all around us. We enter into several contracts almost every day. And so it's interesting when you think of it that way and you get into how it is governed, what are your rights, and what are the rights of the other parties. You might be entering the contract not knowing, but once you understand what contract is, and what the law is, and what your rights are, and what your obligations are when you enter into contract, it helps you, it guides you as you go along.
The starting point of the law in relation to contracts is this notion of freedom of contract. Two parties, without the interference of the law, are able to come along, argue out, have a bargain, reach a price for what they're going to sell, and really the law is only to make sure that if you intended to have that bargain and one of the parties breaches their promise, the law will come along and help in those circumstances. So that's the starting point of the law. However, over time we've had, particularly in the 20th and the 21st century, the development of major companies, huge companies that mass produce goods and sell to a mass market. So you don't really have one bootmaker selling to one buyer or one candlestick maker to a buyer, and there's much more evenness in the bargaining position. Really, we've evolved to a situation where we have one party is huge and the other party is just little u. So there's obviously an imbalance, and often contracts are on a take it or leave it basis. You buy it on the terms that I sell it to you or forget it. So there's no real bargaining going on. So the law has realised that at least in relation to some contracts, particularly consumer contracts, there is no real genuine equal bargaining power, and so the law will intervene in that situation and force certain conditions to apply to those arrangements, regardless of what the parties intend. And I guess the question is, at what point is the law interfering too much? And to what extent is the law just balancing things up and keeping things on a fair and even basis?
There's a general misconception that contracts must be of some specific form and must be in writing, must be signed, maybe, and celebrated or toasted. Many people don't realize that we enter into contracts all the time. I mean, there's simple contracts. You get on the bus to be taken from one point to another. You've entered into a contract of carriage to be transported. You bought a petrol, you've entered into a contract. So most contracts don't need to be in writing, don't need to have any special celebration around it. There are only a few contracts at common law that will require some special forms of documentation. Even those are actually required by statutes, going back to a statute now called, commonly called the Statute of Frauds of 1677, which introduced that certain types of contract must be in writing, or at least must be evidenced in writing. So you can have a contract and then put it in writing. In Australia, especially in Victoria, where we are, there are only two types of contract that needs to be evidenced in writing. Contracts relating to land and contracts of guarantee. But otherwise, any other contracts doesn't have to be in writing.